As a landlord, if you need to evict a tenant, there are specific rules that you must follow. You cannot just change the locks or throw out the tenant's belongings. If you do, it's called self-help and you can be liable for damages. If you don't follow the exact steps outlined in the Illinois eviction process, you will not be able to evict your non-paying tenant. It's a scenario that requires not just patience and understanding, but a thorough knowledge of the legal proceedings involved. In Illinois, serving an eviction notice to a non-paying tenant involves specific steps that must be followed to ensure that the process is both fair and legal. In this video, we'll break down how to serve an eviction notice and how that works in Illinois. I'm Scott Richmond. I'm an Illinois real estate attorney with the law firm of Ariano, Ritt. And since 1981, we've been helping Chicagoland landlords with their tenant problems. And when it comes to tenant and landlord relationships, we've seen it all. Illinois law mandates that landlords provide to tenants a clear written notice before proceeding with an eviction action in court for non-payment of rent. Now, this comes in the form of an eviction notice, which is formally known as a notice to quit or demand for rent. The purpose here is twofold. Number one, it informs the tenant of their breach, in this case, non-payment of rent. And secondly, it gives them an opportunity to rectify the situation and stay as a tenant before further action is taken. However, there is one caveat to what I'm saying today, and that is in Cook County and in the city of Chicago, they have special landlord-tenant ordinances with different requirements. So what I'm saying here today may not necessarily apply to an eviction in Cook County or in the city of Chicago. The first step is serving an eviction notice on your tenant, which begins with the drafting of the document itself. Now, the Illinois Supreme Court has recently made this much easier for landlords. The Illinois Supreme Court has posted eviction notice forms on the Supreme Court website. And if you fill out this form correctly and serve it properly, the courts are required to accept this form. This notice states that it is providing 5 days for the tenant to pay all past due rent or face eviction. It is crucial that this document include the date, the tenant's name and property address, and the amount owed, which is limited only to rent. You cannot include late fees, you cannot include unpaid utilities, and you cannot include other non-rent expenses. It also has a statement indicating that there will be a termination of the tenancy if payment is not made within those 5 days. Accuracy here cannot be overstated. Any mistake may invalidate your notice and result in a lawsuit being dismissed by the court. The next step is delivering that notice. There are 3 acceptable methods of service. 1, personal delivery directly to the tenant. Number 2, directly delivering the notice to the property and leaving it in the hands of somebody who is over the age of 13 and is living at that residence. The third way is mailing it via certified mail or registered mail with a return receipt, which provides proof of attempt should you need evidence during the potential future court proceedings. But with that notice, you have to make sure that there is proof that the tenant received it, because if the tenant doesn't sign for that notice, it's not valid service. There actually is a 4th way of serving notice, but we never recommend that landlords use it, and that's called posting, where it's posted on the door. The reason that this isn't valid in Illinois is because it is only allowed if no one is in actual possession of the property. And what that means is the tenant is not living there. That isn't valid just because the tenant's not home when you go to serve that notice. The notice can be served by the landlord, or it can be served by anybody else over the age of 18. But you cannot use the posting if that tenant is still living at the property. Now, choosing one amongst these methods and ensuring that you have proof of delivery plays an essential role in validating your attempt should a dispute arise later on. Once the notice is drafted and served on the tenant, if the tenant doesn't pay the unpaid rent within the 5 days in full, even partial payments are not enough to invalidate the notice, the next step is to file an eviction suit in the county court. It's highly recommended at this point, or even earlier, to consult with or hire a lawyer who specializes in real estate law in Illinois, since navigating the court systems can often become complex and overwhelming without proper guidance. The eviction statutes are very specific, and the failure to follow those rules can result in your eviction being denied or the case being dismissed, and then you'll have to start all over again and incur additional expenses and additional time and additional months of that tenant not paying rent while still occupying the property. Once the notice has been properly served, and if the tenant fails to comply with the terms of that notice, the next step is to take your case to court. Court processes include filing the relevant documents, including the proof of service of the 5-day notice, attending hearings when both parties are present and can present their cases, and awaiting a judgment which could result in either granting possession or dismissing the case should a landlord fail to prove its claim against the tenant. Remember, always as a landlord, consider the possibility of reaching an amicable resolution with your tenant outside of court whenever feasible. Doing so will likely save the landlord time and money and help foster ongoing relationships. But if you find yourself in the situation of needing to proceed with an eviction, schedule a time to meet with our team to review your situation and get all of your options. There's no cost to speak with us, and we will tell you up front all of your options.